Good morning, everybody. I guess I should say some sort of beginning thing, like it's me, Ali, your host for this morning, without her most handsome, brilliant co-host, Bob Motta. So I was just looking, we got some, a new motion that just came down on Delphi. Let me just put the screen up here so we can see if this thing starts. I think that's good. Small face, giant face. I don't know how to fix it. How come it never looks weird when Bob is just one face on the side? I'm doing something wrong. There you go. Thank you. Thank you, Dizzy. So I don't know if we should like cheat and look at that or just wait. But good morning, everyone. Good morning, everyone. And thank you, Suzer, starting off the morning early with a super sticker. Amazing. But I mean, my plan was to talk about the notes from yesterday. So what did I, Veronica says cheat. Well, I haven't even looked at it, so I'm not even sure what it is, but at quick glance, it looks like some media stuff. And then the defense filed a written motion responding to the motion in limine, because for those of you who don't know, from Delphi yesterday, the judge sort of snapped at the defense, like, did you provide me in writing the cases that you're relying on? She's like, well, I just got the motion, like Wednesday, or I don't know if it was Tuesday, the day before, right, it was Tuesday. So she did a written response. So I don't even know if it's all that interesting yet, but what is interesting, and maybe we can stick it in the chat, is that the judge said that, damn it, I was trying to glance through these so quick that now I'm not sure where I saw it. She put out a new decorum order, and it said that, maybe this is it. Yeah. That press who meets the Indiana Code 34, I'll put it right here, actually, 34-46-4-1 are invited to contact the court to be considered part of the media and be in the pool. Indiana Code. So Gretchen says, please cheat as well. I think that's it, though. she put another order in about the offer of proof, but it's all basically the same. I don't know if that was, because I know we've already covered that the defense had asked, because this order's dated the 16th. The defense had asked to not have to repeat everything they did pre-trial and the offers of proof, and the court said okay. Then the court denied a request for recording from the news media, Wish TV. Then she set the new decorum order, which, in addition to defining who press is or media is, reminds everybody that there's no electronics, food, or beverage in, and that press passes to the trial will be distributed on 3 p.m. October 17th. The 12 press passes will be provided to representatives of Delphi Trial Media Coalition as organized by Cindy Herbert, WTHR, on behalf of the news media, as again defined in that specific section. So to join that coalition, you've got to fall within that statute that it looks like stuff's happening. And then the other one is news media. Oh, about trial exhibits. All right, I'll have to look at this, and I will tell you guys what it says. And then the motion in limine for the response to the sketches, which they responded orally yesterday, is the other thing that came in. But I'll skim it while this at some point and let you know if there's anything different in here. All right. So you know what I do want to do, though, before I do that, is get back to where I was, which is Dizzy sent me notes on, from yesterday with Boone. So let's just go over what happened yesterday. So they were allowed to keep in the fact that in the family law case, the ex-husband is not paying alimony while Boone is in jail. And then they're not allowing the 911 calls where the defendant indicated that the defendant said that they weren't going to be using them. The news footage that was at issue, the court's not allowing that in. And the iPhone photos that the defendant said that she wouldn't be using either. The judge is going to rule this morning about the 119 pages that the state of discovery drop that the state gave them so last minute. I'm sure Bob's fine. Sorry, now I'm bouncing around looking at the comment about Bob getting in. I mean, you guys were telling us last night that people were lining up. It was like, I don't know, 10 o'clock at night. I don't know if that was real or not. So they're allowing the battered spouse syndrome if they produce evidence necessary during the trial, which is what I thought the judge basically alluded to and said as far as the expert opinion. But I think when we talked about this last, I was like, well, they didn't really make it clear. Are they allowed to put in other evidence towards it, like any of the reputation stuff or during the state's case in chief or not? So what Dizzy's explaining to me is the state filed another objection to battered spouse due to no overt act. The defense wants the state to provide a more detailed statement of particulars as to why Boone is charged with second-degree murder and claims the overt act was Jorge trying to get out of the suitcase, which is the same position that they took at the last motion that we listened to, that he poked out these two little fingers, and that was the overt act, that the two little fingers were like the same as a gun, and she doesn't have to wait for him to pull the trigger. So that's they're still going with that. And I don't know, did the judge seem to say that was did the judge mention at all whether those two fingers were sufficient overt act under the statute? We'll see what Diz has to say. And then she said that the state said second-degree murder due to her statements that Jorge in the video, plus what she said during testimony at the recent hearing regarding the battered spouse syndrome and Jorge's autopsy. Again, Boone has to testify as, to the narrative for those. All witnesses without depositions will be excluded from testifying at trial. What does this mean? Is this true? I don't even understand that. Without depositions. Maybe is that an expert witness thing? Sorry, guys, trying to catch up on Boone after having done okay, so after having done court with Bob yesterday on Delphi, and Dizzy says, so I guess I think we both went to click on it at the same time. The late disclosure, there's not enough time to do depositions of new witnesses. So if the late disclosure, I take it, encompassed something of a witness they were already aware of or deposed, that's fine. But if it's a completely different witness, they're out. Do we have any idea if the state lost anything good from this? I wonder. I don't know. Sleuthy says, I know the defense was trying to throw in regular witnesses. They're basically saying if the state didn't get to depose them, they can't testify. Now, did the state actually depose? Because we were talking about this again yesterday on Delphi. And I'm sorry if I'm assuming that most of the people in here are also following Delphi. I see so many of our the normal gang in here. So I'm assuming, that basically all of you kind of do. So, in Delphi, the state did 2 depositions, like the whole entire time, while the defense did 70 or 70 plus. I don't know. They did a last-minute switch with experts because there was one not available. Okay. I don't know let's see what Dr. Vonda said. Hi, Dizzy. Grateful for all you've done to share docs in case. I won't ever be like that. It won't ever be like this in any other. I've carried a worry for it. Feel like everyone did all they could for justice. Yeah, I mean, Dizzy's amazing. And there's their Discord seeking justice. So they've got docs for all the big cases, big and small. Yep. So I don't know. I'm still trying to wrap my mind around whether or not I understood what we heard at the last hearing where I was with you guys, with the text messages, because Bob mentioned another text to me yesterday. Can't remember what it was. But it was also really bad. Now I'm talking about Sarah Boone texting Jorge's brother about hide and seek and getting rid of him. I mean, I don't know if getting rid of him means like breaking up with him, all caps, but in that fight, the fight that was part of the issue pretrial here where Jorge ended up in the hospital. Jorge's the victim. And the state argued, well, that was his brother just beating him up at a family party. So I'm like hearing all those things and starting to think, well, wait, what was going on with Sarah Boone and Jorge's brother? She's texting him about hide and seek, and she's texting him about getting rid of him. He's beating up his brother. Thanks, Samantha. Yes, Bob is at the Delphi trial. And I figured I'm here only because Bob and I have to leave for Breckenridge. We're watching the coverage for trial TV. So that's great. I know we were able to get some streams before when we couldn't because of trial TV. So, and Amy Hatcher, she says, thank you for your coverage. Well, thank you, Amy. I appreciate that. And those of you who don't know, and like I said, it seems like we got the usual suspects in here. So most of you do know. I kind of hate doing these just me. It's so much easier when you have somebody like to bounce off of. I know Bob's used to it and all the other YouTubers are used to it. I still hate it. So but thank you very much. I appreciate it. So I don't know, does anyone else think that there could have been something going on? Like what do you guys think about these text messages that came out? Like, are they nothing? Am I like getting all worked up over like nothing, or does it make you wonder what was going on with Sarah and Jorge's brother? Or like, was there, what are these texts, these weird texts about hide and seek and getting rid of him? Let's see. Sabrina Cerna, $5 holla, as Bob calls it. So cozy in here. Thanks, Ali. Bob got a seat at Delphi, right? I sure as hell think so. I mean, it's 9:19. Yeah, Bob had a seat. Bob had that. He was, unless something strange happened, Bob had a spot, and he doesn't have to worry about that throughout the trial. So, and it's 9:19. So if something bizarre happened and his spot was taken, then I'm sure I would have heard it by now. Veronica says Bob's great, but I'm pretty cool too. Well, thank you, Dr. Fonda. I'll save all this praise over me for when Bob's here. He loves to do that, but I appreciate it. I do. So I don't know. No one's really bouncing back at me about these texts and in Boone, and if it's speaking to some sort of so Dizzy is saying, I think, yes, there was something going on. So I guess she's talking about, I don't know. It sounded to me, the way it was introduced was like she was doing both brothers. I mean, again, this is, us sort of, uh, you know, taking, obviously those texts were read out of context. We didn't get the whole thing. And like I said before, like, I don't know, maybe it's possible that, like, it is weird to play hide and go seek, like adult hide and go seek, that it's like a thing. Um, and, um, and so that's why there was a text about it. And I guess I'm going to get rid of him could mean I'm going to break up with him. They could be taking these two texts from different times, and the way they presented it right there together made it sound like, wow. So we'll have to wait and see. And but it's easy to get carried away when you hear it like that. I mean, that's where my mind went right away. See, Amanda says, I think they will say it was George texting since he used her phone, but the hide and seek wouldn't fit him if it was. And I talked about that when we were on the live, when they were talking about the text, that was an issue, that he was using the phone. But why would he be, texting his family that he's going to get rid of himself, like, and why would he be texting um about the hide and seek? I don't know, but it's just all. And then Bob told me something yesterday. Tracy O says, I think she wanted to play the victim to anyone willing to listen and continually set poor Jorge up. And that included having a relationship with his brother. So Tracy thinks maybe she was having a relationship with his brother. I don't know. Are these the only two things that's like ever come up that makes us think this about a relationship with the brother? Was this something people already thought? Was this something that was sort of out there as like what was going on? Or um let's see. Afton says uh there were rumors of Sarah Boone having affairs, and the way she talks about one set of neighbors makes me think she may have been with that guy too. She thinks that's Eli. Um, and hey, I mean, maybe she was having an affairs, and it was just the part of it that was kind of concerning me was like the brother beating him up, and then her having these texts with the brothers was like, you know, is this something more intentional, you know, than we're thinking? I mean, that's what they're alluding to with those, um, with those text messages. But like I said, I mean, we'll have to hear it. It is easy to get carried away, but that coupled with the like hitting him with the bat, I mean, all the things that made it sound so much worse at the last hearing. Like he pokes his two fingers out with his crazy overt act, and she's hitting it with the bat. But I do still think, like, at the end of the day, um, like, she fell asleep and she didn't mean to murder him, but kind of weird. So Sloopy's like brought into a fight over her. Wonder what her communication with the brother was after Jorge's death and up through her arrest. I feel like if there was more there, they probably would have alluded to that as well. But maybe not. The state could be holding things back. And I don't know, is that Sinead? Sinead? That text is shady, Allie. No defense for it. Can't this be addressed in her narrative? Can it be addressed? Yeah, it can be addressed. I mean, she can testify to explain these things. The state kind of kept saying, well, we're sure she's going to try and change her story on the stand, or she's going to come up with some sort of narrative for this. And um we just, don't know what that is. Samantha asks, Allie Law, do you think she's crazy for going with battered spouse syndrome? I don't think there's any way she can win with that. Bad trial strategy, in my opinion. I mean, that's my opinion personally. There's a lot of this case that I do not know, but on the little that I do know, it seemed off. But with what we learned, um, at that last hearing, and I don't know if some of that we only learned because she was going for battered spouse syndrome, like the whole hitting him with the bat and shaking him and kicking the suitcase with him in it, and not letting him get his fingers out. Like if that is all stuff that was already um out there, and so she had to use this battered spouse because the evidence was a lot worse than what we already knew, like these text messages or whatever else there was. Because before, I really thought it was just more like, no, this is not an intentional act. This is not a depraved heart. This is, you know, an idiot, being, yeah, trying to get back at him for one extent, like, "Ha screw you. I'm leaving you locked in this suitcase, asshole." But not thinking that he was going to die by any stretch of the imagination. Um, and then I don't know. I mean, like I said, I could be just letting my mind get carried away with these text messages and um, you know, God, look at her. She seems a little like she wants to look like a lawyer, you know? She's like, she's got her files. She's got her little suit, lawyer looking suit on. So maybe she created some of that stuff to fit into battered spouse. 'Cause I see Sleuthy saying, and I'll have to check um, the Florida statute. Uh, I'm assuming there's no sound yet, right? Not just me. But Sleuthy was saying, um, like, because most defenses, you have to admit, like, the underlying crime. So what Sleuthy's saying logically makes sense legally. Uh, well, then she's got to admit she did something wrong if she's putting forth a defense, which means she has to admit that she intentionally let him die or some sort of hand in his death, which she did. I just I've always struggled. I've had other cases I've struggled with affirmative defenses as well, because there's some case law out there, depending on how you're using it, that an affirmative defense should be able to be sort of like an alternative, but only in very narrow exceptions where you're dealing more. I can't hear anything, or can we? You guys hear this? Oh, I hear some kind of sound. Well,
Good morning. Can you please state your full name and date of birth for the record?
I better boost this.
10-10-7-7. All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to
That
her
better, guys?
person. So we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 is identified in the defendant's fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Do I need to? Oh, the sound's great now. Okay. Because we got one saying great, one saying boost, but I don't know if it came through late. I think right now,
Of those 119 images, how many are being sought? 15? Okay, thank you.
let's just see
State
how it gets
response.
when the state responds, because I don't know if it's the defense wasn't standing in front of a microphone.
Apparently, these are all
Yeah.
just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119
Okay.
pictures that still not in a PDF form. So of the 15 pages, the first two that they list are pages 9 and 10 out of 1.
What?
The Bates stamp from the hospital is over other text, and there is no other Bates stamp.
Turn
So
my
I had to,
down.
I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't
Am I
understand the
still
relevance of
equally
those two
loud?
pages. Pages 21, and then they skip 22,
Yeah.
23, 24, and
Go ahead
25
and love.
are all part
Thank
of her initial assessment on 123.18.
You guys let me know. Is my
We
mic
don't
too loud?
object
Turn
to
it down.
those pages, but for, and I apologize that there is a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26,
Turn myself down.
we are going to experience relevancy issues and a 403 objection from the state. And that is because in her
Am I still too
toxicology
loud?
screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165
I'm
for
louder than the
ethanol,
court. All right,
meaning
so I'm going to
when
talk
converted,
normal. I'm
it's
still louder than the court.
0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, two. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get
All right, I
to that
turned it
point,
down
is also a
again.
medical doctor.
So
She's a
everyone let me know if I
psychiatrist,
need to
not a
boost the trial
psychologist.
anymore or I need to turn down
Um,
my mic anymore.
Will tell us that ethanol is a central nervous system depressant.
I'm
I
gonna
believe even
rewind
a
this
psychologist
bit
will
because I'm
be able to get that information in.
talking
So
over it and all this stuff.
we are objecting to pages 21. Is treatment for depression from the it does at the bottom of page 25 begins her toxicology screening, and that does go into page 26.
Here.
And they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165.
Is the trial
ethanol
too low?
Meaning, when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant.
All right.
We are going to have at least one medical doctor, well, two.
It
The
keeps going.
forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist.
As loud as it goes. So.
Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment
Thank you.
of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48 and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was
Bless you.
tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete. And
But they are also seeking 49, correct?
Yes.
Thank you.
Just they just skipped 48, just like they skipped 26.
Okay.
Page 63. It appears to be repetitive, but we don't have any particular objection. Page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018. So we don't object to that. So basically we're asking for pages 26 and 48 to be included.
Okay, thank you. The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State, 369 Southern 3rd, 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
Judge, I did check with my secretary, Margaret, and my understanding is I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. I think it was yesterday or the day before that she was aware that they had not been disclosed. We provided.
All right, I'm gonna try to stop and reshare, because to me it's loud as hell. Like everybody's loud, everybody's clear. I have it boosted as high as it went. Then so Meg's saying it's very loud to her. I had muted myself, but then I also changed my settings, the microphone a little bit more. So okay, Sleuthy can hear it just fine. But Sleuthy, you were also saying it's like kind of low, and that like the one lawyer still doesn't sound like he's talking into his microphone. But for me, they're all really loud. He sounds like it. All right, loud but fine. So now it's too loud. Well, you guys can turn down, right? So too loud is better. It's not loud, but I can. All right, so people without earbuds, it lowers for me. I think I fixed the whole lowering for you when I speak thing. All right, so let's just do this one more time. I'm gonna rewind it so we can all, you know, mess with this for a second. And then I'm gonna try stopping and resharing because I don't get why it's doing this. All right, here we go.
Sometime last week, he was unable to provide any specific. Are you in a position to advise to the state, specifically the Advent Health?
My understanding is, I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. It was yesterday or the day before.
All right, so I'm stopping right there to just hear because to me, the defense attorney is now, this morning, I couldn't hear him. He wasn't talking to his microphone, but now he's coming through like loud and clear. But to you guys, you're still not hearing the defense loud and clear. Is that fair? Is that what you guys are saying? It's so weird. And I'm going to rewind it, Diz. Don't worry. I'm going to rewind it. And then we'll have some bloop bloop sound. I can hear him. He's not loud like the judge in the state. The defense is very low. All right. So I'm going to, there's one other thing I can do, but usually it works when I do it this other way. So I'm going to stop sharing. I'm going to come back here, turn the boost on again, just to make sure. I'm going to turn it all the way up. Now I'm just going to play it for myself. And so weird. It's not actually boosting, even though it's saying it's boosting. And that happened before. Volume, stable volume, quality. All right, wait. So volume boost on.
That they were provided via USB yesterday.
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yeah.
Okay. Anything else, sir?
Now this lawyer is definitely not as loud to me. But I'm going to go back to this lawyer and see if you guys can hear him.
Or that she was aware that they had not been disclosed, we provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital. So we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay.
All right. And guys, don't worry. I'm going to rewind this to wherever you tell me. But it's just really strange because to me, all the lawyers, except that one lawyer that I was like, well, that guy's not talking. But this lawyer, and is this Kay? I don't know who anyone is. like I can hear him loud and clear. And it sounds like some of you are still not hearing that lawyer loud and clear, because I can also boost on this end. So I'm gonna let it play for another minute, and then I'm gonna ask you guys again. And if this is annoying the shit out of you, just tell me and we'll move on from it. But I'd rather try and get the all right. So Owens, can you guys hear Owens loud and clear? Let's do this. Testing, and go.
Okay, and when was the
Judge, loud as hell.
error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that
All right. So Owens, is everyone hearing Owens? She can't hear. It's so weird because he can't hear on other things either, but it's like I can hear. So that's fine. Perfect. It's better than before. Yes, I can hear him. Yes, yes, yes. Okay. So now what I need you guys to tell me is how it is when I'm speaking. Versus, and I hear people saying it's not me, it's him not talking into his microphone, but that's where I'm saying, like, for whatever reason, I hear him like really loud and clear, because the other thing I can do is take out this microphone. So now we're going to play it. I'm going to talk and let me know if I need to turn my mic down even more, or if it decreases their sound when I start to talk.
would have been yesterday morning.
Yeah.
Okay.
And I'm
Anything else, sir?
this lawyer is really quiet to me. I'm louder. Your volume is good. Your sound's great.
So one of my trips down here, I got Sarah Boone to sign a medical release.
All right, so we got Sarah Boone to sign a release. Do I sound fine? Am I too
We
loud?
got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue.
All right, guys, so
Late.
where should we
Yesterday,
wind
the day
Phil?
before,
Let me know where we
that
want to.
she was aware that they
where we
had
wanna
not been
start.
disclosed,
So we'll back to
provided
the beginning.
the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were
Okay.
records that some of the other lawyers, one of the other lawyers had received. And we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital. So we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Loop, whenever you guys
Anything else, sir?
want to. It sounds garbage. Do I sound less garbled now? Or did I just screw up the sound?
Okay, any further argument or positions with regard to the Richardson analysis, Mr. J?
Yes, for the purpose of this hearing, I'd like documents.
So I
Is
had
that the 119 pages, sir?
No, sir. It's the 81
my
pages
background
on September 27th.
still muffled. My
Any
God.
objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
I'm muffled. Ay, 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 guys, this is annoying the fuck out of me. So, no, I mean, not like you guys, but just that I'm muffled. Court is clear. You're a bit garbled, but I can hear you. All right, garbled. So, Allie's clear to Rick. Sound is fine to me.
There was just a reference that
Oh,
the
I'm gonna
pages
wait.
were all marked
I
up
think
by the defense. There's no
what I
no
did
markings.
was I had
The issue
turned
and the
off
confusion that the state attorney's office
my
still has, though,
background noise before.
is page
And when you said I
68
was garbled, I
of
turned it back on.
81
Maybe
of these
that's
original 81 documents.
okay.
If you have a cell phone on, they need to be silenced
All
and
right.
turned off,
Removed.
please. Ask for you to be removed.
A time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes,
entered
sir.
as 1, correct?
Yes, sir.
Thank
It
you.
is sub-labeled within these records as page 2 of 14. And it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I have not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance at those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide
Okay.
information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may,
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason,
As a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages, 26 and 49 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted.
That was just because I was muted. All right. So what I was saying was about the sorry guys. I pulled a Bob. Damn. That the rule of completeness is the judge is saying that the state. So my example that I was giving when I was muted was that let's say that somebody's one side's cherry picking text messages and the other side's like, no, 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 we need to get them all in because that tells the story, that gives the context. That's it's like not proper context with that in. So that's the rule of completeness. It sounds like the state is saying based on the medical records that the defense has identified, they under the rule of completeness have additional records they want to get in, and no one, and the defense is not objecting. So the judge is allowing the defense's evidence, even though it was late, even though he found some, I guess, hardship from it, but he didn't find it was intentional. They complied with what he asked for. So we're all good on those fronts.
Pages 26 and 48 will be included in any evidentiary documents that sought to be moved into evidence with regard to this January 23, 2018 incident as provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they were able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the prospective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
So if you guys recall, this was kind of like my issue with the judge's ruling on the battered spouse. Like he was limited to the expert. Like he made it very clear that the expert could not testify until the defense, until she testified and put in enough evidence to make the testimony relevant and, set out the overt act. And I was like, but I didn't really get a clear feeling of, is he allowing them to mention it in, well, he did say he was allowing them to mention it in opening. That part I was clear on. But was he allowing like evidence to come in or, beforehand or through the state's case in chief about some of the reputation evidence or other incidents? So let's see what the judge says here.
Response before we go through each photo.
So we're going to go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself.
Told you we're going to go through the photos.
We're entitled to put on a case involving self-defense, and under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force,
I'm not discussing the jury instructions at this time.
Told you.
There are evidence of prior threat.
He just gave you your answer. We're going to go through the pictures.
Here's my concern. Why are we addressing law in opening statement?
I agree with the state attorney. I did pull up a couple of these on the justifiable use of non-deadly force.
It does not answer my question.
He doesn't listen.
Okay.
You agree not to use them.
I'm interested in using and opening is the standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense to decide which is the best evidence and which evidence should not be relied upon in considering the verdict.
No, I can see it, sir.
And then the other one is a reasonable doubt is not a very possible doubt, speculative, imaginary, or forced doubt.
This is opening.
What's your position with regard to those two, Mr. J?
Judge, opening statements, we should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the options, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards at opening statements. I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please?
So I just want to clarify there were two different things going on. Owens was about to start arguing to the judge about the instruction in regards to what picture should get in and stuff like that. And the judge was he's already made it clear that the rule that's stated in the instruction is not the same rule he's considering when he's trying to decide if he's going to let him put certain pictures up about the injuries during opening. So now his request to present certain instructions is different than when the judge is like, can you stop talking to me about instructions? This is whether he's going to allow him to use certain instructions. It's unusual for me. I don't typically see it. Clearly, this lawyer does it all the time at openings anyway. And it looks like the judge is even going to be fine with that, so long as it's a proper statement of the instruction. So he's looking at the instructions right now, but then we still have to deal with whether or not they're going to be allowed to introduce photographs of of injuries that Sarah Boone, sustained from the victim during opening. The judge sort of indicated before, not sort of, outright indicated before, dude, at your own risk, do what you want in opening, but it could come back to bite you. And it seems like he's given him enough rope to hang himself on that, because he's like, you do you, this is your defense. And if you're going to put forth a shitty one, then go for it, essentially. So All right, we'll resume.
Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year.
Oh,
That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection.
whew,
3.7 now reads,
there's
proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction.
Mm.
For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from.
Give me a moment.
Oh. No, that's not right. Maybe we don't have a womp womp sound. Nah. I don't know. I got something for now, though. I can't imagine how pissed Sarah is right now. Oh, I still have that crickets on. Damn it. All right. Get your shit together, Allie.
That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions, 6 through 10, we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into
Thanks,
pieces and
Alex.
portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law, that in many ways, we do it where we give them the law at the very end. And I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
And I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please.
We'll do this while she's marking. The joy of the bloop. Wow. See? Look at this. Look at this.
Of the phone. State had the photograph. The state provided the defense.
Bob's in Delphi, guys. Ass tooth lotion for Greenos jeans. I have not seen your jeans, dude. I've definitely not seen your jeans.
Any other further argument with regard
Thank
to the
you.
use of those items pre-marked as A through I in opening statement? Mr. Owens? When did you send it, sir? I have not received it.
Oh boy. It's too bad we can't see Sarah's face again. I think that was defense that said he emailed it.
I think we were already on the list, so we sent it to the clerk and the jail.
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated
Owens is not standing in front of the mic right now, so
a separate one, but I'll check.
and JT Vick says it was the
Is it just
defense
these two cases?
that email that the judge didn't get.
Provided
Hmm.
Alsaguer v. State, 326 Southern 3rd, 656, Florida Supreme Court, 2021. Low v. State, 259 Southern 3rd, 23, Florida Supreme Court, 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Alcaguer case, which is the 2021 case, trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that wasn't in the record. The 2018 case, Supreme Court of Florida, again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound. Advising of the trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim's size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. Court allowed, again, the court's discretion. As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from the norm. I think the two instructions would read, find that Sarah Boone, who because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone are those of a reasonable person. Goes on to say, if you find at the time of the alleged second-degree murder, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact to determine whether Sarah Boone reasonably believed necessary for her to be We have a good faith introduced in evidence. They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes, sir.
Yes, sir.
Judge, the standard is, it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established. And that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, then certainly A would come in, and some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not, a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I, state is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things if we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great, blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that? prior
No, what I
ruling?
ruled is that you were able to discuss them, address them in opening. Photographs are a totally different kitty.
That's what he
I said
ruled.
nothing about battered spouse syndrome. I said self-defense.
No, he said you can say it. Say whatever you want. He's not listening again.
Arguing these. I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties.
He
Prior
understands.
acts of violence. The standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my
Finger.
client, we believe there is going to be evidence of an overt act.
2 fingers.
That she was facing imminent threat, and she reacted based on that threat.
Understood. Your response to Exhibit B.
Could you answer my question
It's
now?
her on the back porch with the 2 dogs.
Judge, not only did he abuse, Juan Torres abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
Mm.
I believe it is a part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce, that they've listed as exhibits. I thought for sure we put this on there, but the relevance of it is
He only
not
asked
only did
about.
he abuse Sarah Boone, as far as he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
Okay, thank you.
He's like, we have proof that we
All right.
freaking
The
listed.
court's
this."
prepared to rule at this point in time. Thank
No
you
more-
both for your presentations and your
Right.
argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to
I really
establish.
do know in my
The
head.
concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about some incidences made happen, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we prepared to
Love it.
bring in our jury at this time?
Got two other issues.
They've been waiting for an hour and 20 minutes, Counselor.
We intend to play the 2-minute suitcase video to the jury in opening statement.
Oof.
State.
I don't care.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
I need to approach the bench.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. It's good for the goose is good for the gander. If not going to allow your photographs, not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you.
All right. Bloop, bloop. Whoop. Here comes Jory.
Not conducted any independent investigation regarding those items. You just urgent to not have any just confirm before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. Then you have not conducted any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you all approach for a moment?
What the hell? He didn't notice the juror?
And a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you.
Oh, the judge is pissed. I mean, he probably didn't say anything to him, but I would personally have taken the next elevator. Now, what do you do if you're on the elevator and a juror walks in? I don't know. I mean, I think I would just I might have just like looked at the ground and kept really, really to myself. I don't know that I would have been like, excuse me, everybody got to get off. You know what I mean? So let's see. And lawyers don't typically.
All right, thank you both for your honesty. I appreciate that. Something we talked about earlier this week. That's the one thing that we required and asked of you is just be open and honest. And I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way to have any impact on you? Juror number 3, left to right, first row.
Wow.
Juror number 4, left to right, first row. Okay, thank you. All right. With
I
that,
thought jurors were waving their hands like, yeah,
members of the jury,
man.
we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. J, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. He was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went off to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. The evidence is going to show George.
All right. So guys, I'm going to mute this a second. I do not understand what is going on. I can hear him. He is soft, but I can hear him. And I have my volume somewhat turned down because it's so loud to me because it's when I have it all the way up. What I am not understanding, it seems to me that the boost is like not working like it should. And I don't know how to fix it. Diz, maybe one of you should share, but then I can't mute. I just don't understand why this is happening like this because Wait, live captions. There might be live captions. Hmm.
George Torres is dead because in
Whoops.
this defendant's judgment, sir,
Oh, that's playing
disregard for whether he lived or died.
the live captions just on my side.
These videos. What I expect
Huh.
to hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah, the defendant will say, "For everything you've done to me." Sarah, "For everything you've done to me." Sarah. And then the defendant laughs. Sarah, "Fuck you." And the defendant laughs. Sarah, "Stupid." Sarah, "That's my name. Don't wear it out." Sarah, "I can't fucking breathe, baby. Seriously." "Yeah, that's what you do when you choke me." Sarah, Sarah, Sarah. The defendant laughs again. Sarah, "I can't breathe, babe." She laughs again. "That's on you." Sarah, "I can't breathe." She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 "I can't breathe, baby. That's what I feel like when you cheat on me." Sarah, "Fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up." Sarah, "Shh," is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound George Torres put into this suitcase left? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, Torres, and eventually realizes, oh my God, he's in the suitcase. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, took his little legs out. At some point she makes that statement and tries to resuscitate him. Here's gurgling as she presses down on his 103-pound chest. Forcing the air was trapped in there. The next thing she does is she doesn't call 911. She calls Brian Boone. Brian Boone. Brian Boone is her ex-husband. Share a child in common. And this state, Monday through Tuesdays be her responsibility. Wednesdays and Thursdays, the child is Juan Williams' responsibility. So February 23rd, 2020 was a Sunday. Now we've led into Monday. Mr. Boone had been trying actually to contact the defendant several times that morning. Playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in steps, was taken to the ninth division medical center autopsy. What the doctor found was what we expect after being left in the suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like Newport, and environmental suffocation. You don't have to have a plastic bag over your head, tape shut with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, yeah, suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion, will help her explain contusions and bruises. She'll use words like hematomas, will help her understand for you all that that means bleeding under the skin and blood, what you expect to improve with blood or other fluid. But he had all this additional trauma. He had trauma on his fingers as well. So now, the sheriff's office, Orange County Fire Rescue show up, and the defendant interacts with the first patrol officer. You will see and hear that body worn camera. It's more of the same as what we heard on the 911 call. Hide and seek. It was good. I fell asleep. What happened? A few hours later, the detectives from the homicide unit at Orange County Sheriff's Office.
I can, guys. And there's this thing they have, like a live captions setting, and the live captions like come up as a separate screen for me, so I can't see it. So if you're on a computer, I'm going to suggest that you open up another window and you click on the closed caption live setting thing, like at the top. There's like what I see on my screen. Wait, let me try. Is it possible? Yeah, this is on my screen. Let's see. Let's see if I play it. Will it make the live captions come?
Approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of the counter that was found at a suitcase by Mr. Torres, and giving it to one of the digital forensic examiners.
You guys can't see it. Only I can see it.
But it's time to give a first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene.
There we go.
And the basics remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge. Bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Boer wasn't even half full. So the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect of a restaurant. Those are 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, so the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces, given that a standard serving of wine is 5 ounces, and there's receipts.
I think it's a pool camera, right,
The day
guys?
before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine, and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that are apparently 103-pound man, and the defendant, who is in the same weight class. And the decedent would leave leftover wine from any given day, remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, and her words again, there was enough room for his little fingers to get out.
Until I beat him with a
We were still
baseball.
having a good time and whatever. And basically, you know, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up.
So not hide and seek.
2 little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're going to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listen to music, play with the dogs. We drink what we try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself.
Wow.
Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, She does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the two videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. Two, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before. Though she described it happened before. Right. I'll never drink alcohol again. She insists that she has no injuries on her. And you don't have to take her word for it, because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words.
I mean, the baseball bat touched him, but it didn't really, wasn't me, it was the bat.
What else? There's a conversation between Mr. Torres's brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Miss Boone.
There you go.
Text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces, nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote-unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion.
I didn't see, I shall.
He describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres. Referring to Mr. Torres, getting rid of.
So that doesn't sound like an affair with that brother.
Danger, keep out, stay away,
All right, so I'm gonna tell you what was said so far because I know you guys aren't hearing it. So he's like, you're gonna come up to this door at some point, and it's gonna say, "Danger, do not enter." I don't know, something else. And then he makes like this vampire analogy. Well, Halloween's coming. So, with a vampire, you got to invite the vampire in. So he's laying this groundwork. And then he says, so you're going to be tried to be introduced, invited in to her story about her past violence in her relationship. So he's about to be telling them that you don't get invited in until the judge tells you. So be what they say, what they will, do what they might. That, and I suspect that's the rest of this sentence. But remember, it's the judge who's going to tell you at the end of the day whether any of that matters. So right now he's gotten to like the door, do not enter, danger, and the vampire analogy. And he's just starting with now she's going to try to invite you in to their past history. So you're going to hear the first night the defendant met the decedent, Torres, smashes her phone, punches her. First time in her life she's been punched, I think. Hold on. Oh shit, what I do? Oh, wrong screen. Sorry, here, hold on. Punches her. First time in her life she's ever been punched. He made her curl up in a fetal position on her own porch for 4 hours. He was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his score on his blood alcohol level when he got here at the hospital was 344. He had serious alcohol problems. You're going to hear about that. Despite that first date, there's some other things that might possibly come in. Despite the first date, despite not having a relationship or emotional connection, because he's saying how when you're in a relationship, it's harder to break it off, but we're talking about their first date. Another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now these dates are at a bar, and there's nothing wrong with that. You're gonna hear it's one thing or another. Like I ask a dude for a cigarette, Jorge comes out, I'm gonna pay the price. Things like that. You're gonna hear him potentially see. Yes, there were injuries that the defendant is going to attribute to the victim causing her. Blackout, cuts in the face, perhaps from a curtain rod, a bloody ear, a stab wound to the leg. She might describe a sword fight. I suspect you're going to see and hear a lot about their past history. And at the end, if this occurs, if this comes in, the state's going to have the opportunity to take lead of the tour in this room. Oh, take lead of the tour in this room labeled defendant and the victim's past history. I'm not going to go into that now. all comes to fruit. We'll discuss it at the end where it's more appropriate. I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on November 23rd. Now, with the home inspector, there are experts. They're going to come in and try and help you walk through this room labeled defendant and the victim's past relationship. I suspect there's a chance we may hear from some experts, psychiatrists, about battered spouse syndrome. State is not challenging in any way battered spouse syndrome. Well recognized. The experts will tell you that. But there's some things we will hope that you pay attention to about this subject matter. One, it's not actually a recognized diagnosis that they use in mental health. Diagnostic Statistical Manual. I don't know what he said. What it is and what they describe it as is a component of post-traumatic stress. But because it's not actually in the book, it's like our statute books. Go into this book, and you say you have a particular disorder diagnosis. They'll say, well, it needs these three elements, like elements of a crime. But because it's not in the code book, you may have some disagreement by the expert. It's like grandma's recipes being handed down by generation to generation. But what I expect you'll hear, it's important for people who don't have experience in abusive relationships to understand the control that can be exerted over a partner by another, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described to you as well, perpetrated on her by the decedent. You'll hear about all this. And what it ties into, at the end of the day, we talked about it during jury selection. If there's a self-defense instruction, this will help you to understand what an objective and reasonable person in this circumstances would do. Because years ago, why wouldn't you leave? That's what the question would be. Battered spouse syndrome, and the testimony from these experts helped explain those things to people. It's not that easy. You got to look at what's going on in the relationship, isolation, control, so on and so forth. Is this helpful, what I'm doing? Returning to the facts of our case, you're going to decide what the facts are, is, you kind of stumble. Ordinary, objective, reasonable person in those circumstances would do. If you get the defense instruction, not used to explain the subjective things that went on. But we do also hear about these things, just like any doctor or any expert, a home inspector. A home inspector's report was based solely on the person trying to sell the house. What would they say about the house? It's great. I rewired the entire thing. Brand new pipe. This sucker's good to go. It's the best house. Something like that. You're not going to take that home inspector's report unless they lift the hood. Now we're going to cars, kick the tires. You want an expert to get reliable information, because the expert's opinion is only as good as the information he or she has. You got to take into account the credibility of the person who's giving you the story. The client that is saying all of these things happen. You got to check reliability, particularly in circumstances like these. Another thing they're going to tell you is just because there's a bunch of non-violent nonsense going on doesn't mean battered spouse syndrome applies. You go home and fight like cats and dogs. That's just their day. They get over it. They go on with their life and fight about another thing. And that's the cycle spins like that. So just because you hear about those things from the experts, if this testimony comes in, I expect their expert to say it applies to Mrs. Boone. But we'll talk to her about what she relied upon to make that conclusion. And we'll talk about some other things. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth, the video, you don't have to rely on anything other than your two eyes and your two ears. State's going to ask you to return a verdict guilty of second-degree murder. The evidence is going to show the defendant killed Mr. Torres because she decided he deserved it, not because the evidence will show an objective, reasonable person in her circumstances needed to. Thank you. All right, I'm going to
Thank you,
pause
Mr. Jay.
for a second.
Any open
So, you know, his analogies kind of bounced around, right? Like he started with, there's this door and it says danger, do not open. The background of Sarah Boone and Jorge Torres, something to that effect. So that's when he kept going back to the door, and he's going to be the tour of this door. And then, like I mentioned before, he moved on to vampires. You have to get invited in. Now, when I paused it earlier and I said, oh, I'm seeing where he's going with this inviting in, I wish he kind of would have made that like clear, like she's going to invite you in, but it's only the judge who really can invite you in. And he didn't make that, really that clear. And then he started using the inspector and giving the tour of the house because he was kind of sticking with like a room thing. You went into this room and the room is their background, their history. But then he started doing like, a mechanic, fixing your car. You got to open the hood and got to kick the tires. So, and I think that the mechanic example was probably the best, like but I understand he seems like he wanted to keep going with this room theme and this house theme. So, but I think it did, portray to the jurors that, the experts getting their information from her. Is she reliable? It was all right. It started strong, like from the emotional standpoint and from like the things that she's going to say. And then you guys let me know if when you don't hear it, you want me to do that for the defense as well. If they're walking around, I can tell you if I was doing this trial, I wouldn't stand at that podium to help you guys hear, because I just don't. I walk closer to the jury. I interact more with the jury. It definitely, I would not have been able to stand at the podium the whole time thinking about, well, there's like the public out there and they want to hear. So Spitfire is saying, yeah, if they're walking around, I can let you guys know what they're saying. So I'll do that. That's why I just think it's weird that I can hear it and you guys can't. It's bizarre to me. And I will continue to do that. All right, so let's go. And at least it wasn't too long. Let's hope the defense isn't too long.
Opening remarks by the defense.
Judge, can we invoke the rule?
Wow.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you.
Oh, I thought he was saying, I'm sorry. I thought he was like, we're going to reserve our opening till the end. But that's not what he was doing. So ignore my wow. He might be more of a stand in front of the podium
You
kind
may
of guy.
proceed, sir.
Nope. I appreciate y'all being here. My name is James Williams. I represent Sarah Boone. And this is the other lawyer. Now, this is going to be a several-day trial. We're trying to make arrangements to assist. And you'll know more at the end of the day. I know your focus is on this case, which is where it needs to be. There's no higher calling than what you're doing. No higher calling. We're going to ask you to do something and find Sarah Boone not guilty, because she was justified in the force that she used to defend herself. That force is reasonable under the circumstances.
Between Sarah Boone and George Torres.
You guys hear that now?
Sarah Boone and George Torres were down and out, as you can be, around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome.
All right, so they tweaked something. So I don't know if you guys want me to stay here or you want me to switch to a different stream. Let's see like how this goes, but I'll pay attention. In my, when I hear it, it's actually fuzzy because it's so loud. So I'm going to turn mine, at least on my computer, down a little bit. So all right, let's roll. Everybody's saying clear as day.
And so day to day, they struggle with the use of alcohol. You can imagine it. It affected their jobs. It affected keeping employment. It affected even getting a job.
Maybe Melanie and I should have done this together. I didn't think about
As
that.
codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences. We took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had, and considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that, all the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the day
That's not me.
of this event for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store
I agree.
about noon.
Oh,
And they come out with one of those larger bottles of the wine.
I
And
sort of
then, of course, there's a receipt.
I'll come back to it.
And the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click. Everybody gets a. There's another video that's approximately 11 minutes later. The first video, George's, the suitcase is flipped upside down. The zipper's put off. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, Sarah. And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from George Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense. You can hear from the medical examiner. She is going to tell you about some bruising on George Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain, but there's some bruising. Sarah's going to explain that to you, why that happened, what were the circumstances surrounding that, involving that. Her son comes and stays with them from time to time. He has his own room. He has several of his things there, and there's a bat downstairs. The same bat that George Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate. Sarah loves you. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had no intent to kill. Prosecutor mentioned she wanted him to die. Farthest from the truth. She loved the man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. Vulnerable. You're going to hear it all. You got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect.
That's an understatement.
You know, she goes, as many of us do when we drink too much, and you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And their son is at Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, I'm coming over. Please come over.
What do I do?
He's about 5 minutes
911?
away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs.
You guys can't hear him?
She called 911. She calls 911 within a minute, 2. Detective Rodriguez arrives. You know, they got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible.
Somehow.
Eventually, she gives a statement to law enforcement. She gives one for Detective or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And, you know, they know what to do. They try to assess the situation. They start putting the tape out, and then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. You gotta hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs, videos, all that. And they find these two videos. Sarah is not aware, she doesn't remember making the video. You can imagine. She gives them the phone. Well, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Hobson is her name. Chelsea Hobson. And they end up, Deputy Hobson was pregnant, or Detective Hobson was pregnant. So they end up, hey, we're not going to bring your phone. I'm not feeling good. Pregnant. Can you come to the sheriff's department? Which Sarah Boone was telling you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead it was an interrogation. And they were going to arrest her. They made their mind up on it. And they were going to confront her and try to get her to confess based on the two videotapes. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon. When she got there to get her phone, they said, well, we got to come up here. We need to talk. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying before you.
I mean, I could buy
We
that
simply ask that you look for the evidence of
to a
cooperation
certain extent. Some people lie, but
of her testimony.
there's a lot.
It'll be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility, and they'll talk about corroborative evidence, other evidence that's consistent with the testimony that Sarah Boone gave. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional. Self-defense nonetheless. Now, as I said, the struggles that occurred, many of them involved the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. The police are there. So her attitude is not one of distress. We're here today, full packed courtroom. Judge Graham's here, but you're the most important people.
That's great for
Because
Sarah.
you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case.
Just
They have the burden of proof,
change that.
and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judgment, to keep an open mind, and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of experts. Battered women's experiences affect her perception of imminent danger.
God,
Battered women's
That's
experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty. Because it's the right thing to do. Thank you.
Thank you, sir. Can the parties approach for a moment?
all right. So we probably do have a little bloop bloop, but well, no, we caught up with all that. I don't know, guys. I think so. Here is my thought. Like, yeah, in my mind, I'm thinking, well, who stays with the guy after a first date like that? But for the purposes of like a battered spouse syndrome, ignoring this case and these facts, I would never consider the two alongside each other. Like, well, she could have left after the first date. Like, so that's why I was like, I agree, but I disagree. And I don't think anyone was necessarily saying that. But it's also, it's hard when you don't have someone's life experiences to know why somebody would see someone again after that. So I don't know that it's like a real fair question to ask. Like, well, she should have never stayed with him after that first date. But yeah, in my mind, sure, she should have never stayed with him after that first date. But I also kind of understand that, you never know what's going on in someone's life and why she felt she needed what she needed at that time, that she was still fine with whatever else happened. I didn't
State,
find-
you may call your first witness.
State will call Juan Torres.
So does anyone know, is Juan Torres the brother that she was texting with? Because when we heard the opening, those texts didn't sound like someone she's having an affair with. It's someone that's like, Sarah, get yourself straight. Like, but I wasn't super um, impressed with the state's opening. And I don't know, am I wrong, or um, he didn't really talk about, like, I didn't get a sense that he was conveying, like, this was all an oversight. She had no idea this was going to happen. And um, I don't know. It just, I didn't find it real compelling. So, and now, you guys, if you want me to change streams, people still can't hear something, let me know once we get to when we start with this witness. We do have a little group.
Sir, good morning. You could be seated. And once seated, if you would state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
6 or 7.
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. In Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, say, on a weekly basis.
And how far away did you live from George?
About 5-10 minutes. Very close.
Would you see him pretty often?
I would try not to go over there too much.
Who was George living with at the time that he passed away?
Wait, Sarah?
And without getting into many details, what was your relationship like with Sarah?
We didn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
All right, there's all that
Back
speculation.
on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
Okay,
My wife and my
different
2
brother,
kids.
guys, different brother. So let's wait and see.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
Just
Why are they
just
letting
talking
this hearsay
like we
in?
normally do. He just calling me to check on me,
Oh, okay.
basically.
Now, in the background of that conversation
I see.
on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
You recognized her voice?
Yes.
What was she yelling about?
Something about choking or how he choked her. I really don't. That was it.
About how long was this conversation that you had?
How's that helpful to the state?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it.
Did she sound upset?
She sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
Mm.
I have no further questions.
Wow.
Any cross-examination?
How long is this trial? Are they estimating?
Good morning, sir.
Good morning.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother George Torres, did he ever stay with you at any time?
No,
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
no.
All right, sir, let's go back to this phone call that you were talking about that was on February 23rd of 2020. And that phone call was approximately 7:30. Is that correct?
Yes, sir.
And who called who?
He called me.
And then y'all were talking. Is that correct?
Yes, sir.
And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No, because I knew when he would drink.
Okay. So in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
Now, you said you heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
I can tell her voice.
You recognized her voice. So you could hear her. Is that correct?
Yes.
All right. And you've heard Sarah speak before that time. Is that correct?
Yes.
And you've heard her speak on the phone before that time. Is that correct? And you said that Sarah was yelling. Is that correct, sir?
Please don't.
She was yelling about,
Don't
he's
do it.
choking me. Or tell him about choking me.
Yes.
Okay.
Okay.
During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Not really.
You've heard it before?
No.
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No? Sir, at some point, your brother said he had to go, is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have. If I can.
You may, sir.
Sir, other than siblings, your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
Thank you, sir. No further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
State would call Devin Jamro.
Sir, good morning. You could take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's DevinJamro.
Thank you. You may inquire, sir.
Sir, who do you work for?
I work for Public Supermarkets.
And what is your position with public supermarkets?
I am the assistant store manager.
And at what location?
Currently at a Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Your Honor, may I approach the witness which has been previously marked for identification as States D and been shown to defense?
D's and Delta?
D as in Delta.
Yes, you may.
Sir, I'm showing you it's been marked for identification as States D. Could you use these scissors and open this and look at the contents of this package to yourself?
Sure.
Sir, do you recognize those items?
I do. Yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from
Yep.
Your Honor, at this time, I'd like to move what's previously been marked for identification as States D into evidence.
Any objections?
No objection.
What was pre-marked as States D will be received into evidence without objection as States 1.
Your Honor, may I approach the witness who's been previously marked for identification as States J and shown to defense?
You may.
Sir, I'm showing you it's been marked for identification as States J. Can you take a look at that disc?
Yes,
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did. Yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes.
And in the normal course of business, are the videos from those surveillance cameras kept?
Yes.
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
Yes.
And they fairly and accurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
They do. Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as States J into evidence.
Any objections?
No objection.
What was pre-marked as States J will be received into evidence without objection as States 2.
And I have no further questions for this witness.
Any cross-examination? Can this witness be released?
Yes.
Yes.
Thank you, sir. You're released.
Thank you.
Have a great day. State, you may call your next witness.
State, we call Joan Williams.
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay, Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at Orange County Sheriff's Office,
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for emergency, non-emergency, medical, which I transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes.
And those records are made at or near the time of each call, correct?
Yes.
Your Honor, may I approach the witness what's been previously marked for identification as States L and been shown to defense?
You may.
Ma'am, I'm showing you what's been previously marked for identification as States L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
It was pre-marked as states L will be received with no objection as states 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
Can this witness be released?
Yes, Your Honor. Yes.
Thank you, ma'am. Can the parties approach momentarily?
We're all caught up. Uh,
State, you may call your next witness.
State will call Vincent Baglia.
hey, thanks. And I don't know if I'm supposed to say last names, but another lunch day in Delphi, $25. Thank you, thank you. And thank you, Afton.
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Baglia, Vincent Battaglia.
Thank you. Sir, you may inquire.
Good morning, sir.
Morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Them.
That's Brandon Moes?
Yes.
Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and George Torres?
Yes.
And approximately how long were you neighbors with them?
About a year, a little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for a child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time
It was
was this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like it probably 4 to 5 months before that.
So 4 or 5 months before February of 2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like if I do hear anything like through the walls or whatever is out back, just kind of keep my mouth shut. Like don't really speak about it or anything like that or say anything to anyone. And I just was like, okay.
Did she make any motions with her hands?
Yeah, like just kind of like, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there.
Yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake and stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Shuffling.
Could you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. At the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah. All the time, it was like a back and forth.
So other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument?
No.
What was the last sound you heard?
He said
The
that.
last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, then it was just like a loud rumbling noise, like that literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment, so it was like there's like a little kick out next to my patio, and that's like that was my bedroom back there. like along the grass back there.
On the first floor.
On the first floor, yeah. Yeah.
I have no further questions.
Any cross-examination?
He's like, okay.
Mr. Baglia, good morning.
Good morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year.
Yes, sir.
Are you aware that the police were called to their residence
Like,
while you were there for the year? Are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on multiple occasions. So that's why.
Just instead of what somebody else told you,
Yeah.
just what you would observe. Did you ever,
He just said no.
the year that you were there living next to them?
Yeah.
Were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
And did you work odd hours or you went?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first, please.
Do you know from your experience with Sarah Boone and your experience with George Torres that they drank alcohol?
Yeah.
Hang on.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you.
Yes, sir, of course.
He's not helping himself.
Vincent, I think you had testified, you may have given a statement to law enforcement,
Yes, it was one of the detectives.
a recorded statement?
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time. Yeah.
I believe you had said that,
I'm going to object this to improper impeachment.
Approach.
All right. So now he's obviously trying to impeach him with something he said before, and the state doesn't think it's proper. So they're going to tell the judge, well, what is it you're about to say that he hasn't already said, to determine whether proper foundation has been laid and whether or not it's actually impeachment.
Objection's overruled for now.
All right. So we
so
get
would it
to
be
it.
fair to say on that date you got home around 7 p.m.?
7 p.m.
Yes.
Which day was this?
Sunday, February 23rd, 2020.
No, that day I actually got home from work probably around 1 or 2 o'clock or so.
In the morning?
No, in the afternoon, because I went to work that morning at around 5 a.m.
And you said that you heard the normal yelling and arguing at about that time when you got home?
No, it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could very hear clearly. It was like around 10:30 at night.
Okay. Thank you.
I guess he ended up not needing to impeach him.
Thank you.
Any redirect?
Just very briefly.
Yes, sir.
So on cross-examination, you were asked about the arguing you heard, and I believe your testimony was that it was pretty intense around 10:30.
Yeah.
Approximately what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like the arguing I could hear started.
No other questions?
Can this witness be released?
Yes, John.
Not subject to recall.
We would like him subject to recall. You've got his number.
Okay.
Your Honor, may we approach?
Yes.
So what did we say? We said 11:15 is when he heard the loud noise, and that's the last sound that he heard. He's also describing some arguing earlier, but says that really ramped up around 10:30. I don't know why the state's objecting. They can put their witnesses subject to recall. I think that's what they just approached about, but how you guys feeling about this so far? Anybody got anything to say?
All right, sir. You are released, not subject to recall.
What?
Great day. Thank you.
What?
The state would call Brandon Moes.
If he not, I don't get it. If they're saying, well, he didn't list him as a witness, I always write on my witness list
Bless you.
all the people that the state listed, and so and so and so and so and so and so. So the defense just seems to be focusing on they're both alcoholic, and his other brother.
Thank you, sir. You can be seated. State and spell your name for the record for us.
Yeah, my name is Brandon Moats, BrandonMoats.
Thank you. Mr. Cacciatore, you may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so, when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021. 2022.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Baglia.
And during that time, what were you doing?
Like,
as far as work and school? And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with George Torres in this case?
Honestly, I avoided them as much as possible usually.
The apartment where you lived, tell us, how would you describe the walls that separated
So,
your units?
yeah, I remember that my bedroom was like the front-facing bedroom, and our walls shared a wall with where their staircase was. So, like, the way the apartments were laid out, we had a one-story apartment, they had a two-story apartment. So they had a staircase running right next to the walls, next to like our bedrooms.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin, so if people were yelling, you could definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued very, very often.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock. That evening, probably like earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that we can paint the picture, where would that, would it have been on the first floor or the second floor?
We had a first floor apartment.
Okay. So all the units were, or all the bedrooms were on the first floor?
Yeah, like I was saying before, we had a 1-story apartment, and then they next door had like a 2-story townhouse. So we only had the 1 floor.
And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, at literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling. And it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me like it was falling down the stairs.
Did this affect the walls that were between your 2 apartments?
Oh yeah, me and my roommate, I remember me and my roommate talking the next day about like we could literally like it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, yeah, I never saw her after that happened.
No further questions.
Any cross-examination?
Good afternoon, sir.
Good afternoon.
Sir, you were asked by the state if you ever had any interactions with Sarah Boone or George Torres. Is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yeah, I don't like drunk people, and they were drunk a lot, so I did not interact with them.
Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah?
I would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019, when you woke up and witnessed Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I like saw her.
So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay, thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school and she was trying to talk to you and she seemed paranoid and rambling?
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really.
And I had just commented because I thought it wasn't going to be this witness that he was. So I was like, oh, so the witness you just didn't get subject to recall. But then it ends up he actually did see her. He was just explaining that how he came to see her was like the rumor was like, hey, go look out there kind of thing. So
really remember too many like details of what she was saying because I didn't want to talk to her. But yeah.
Okay. Do you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what she was saying, but like the vibe she was giving off was that she didn't want to go home.
I believe, and I just want to make sure that I heard you. You said that the first arguments, other than the boom, which was like 10 something, initially it was around 7 p.m. You heard arguing.
It would have, yeah, because it would have been. I remember that day I got home from class around 5, because I got out of class around 4:30 usually and walked home, so I would have gotten home around 5:30, and it would have been after I took, because I came home, I made myself lunch, and I took a shower, and then I heard all of their arguing, so it would have been about an hour and a half, 2 hours after I got home, so around 7 to 8 o'clock.
And during that time, when you say arguing, was it back and forth?
I honestly, I wouldn't really be able to say if it was back and forth. I don't know too like I wouldn't remember too vividly if it was back and forth.
Well, let me ask you this: Did you hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice?
Yes.
Okay. Were they both loud?
Yes.
I think he was just like, I don't know that they were back and forth, but he was just interpreting back and forth, you know.
If I can confirm, Judge.
Yes,
More
sir.
liberal.
Thank you, sir. I have no further questions.
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Subject to recall, Judge.
All right. All right, sir, you're released subject to recall. Thank you.
I'm so confused why everyone else can be subject to recall except the one guy.
Can the parties approach?
Maybe it was something like this guy had a scheduling issue and the defense was like, I don't really need him. I don't know. Hey, Steve. Got publicly buzzed in the house. And I think we're out of bloops. Let's see. It was a couple seconds. Diligently taking her notes. There she is in all her glory. You know, this is a hard one because I think she was a victim of abuse. There's no doubt about that. But it's just the way that this kind of crime went down. You know, it's how that factors in here is just unlike, you know, a typical situation. And yes, so if a witness is out of state, as Afton asks here, that would matter. You have to get a special subpoena issued from the state that they're in. Then you have to, the state where the matter is. And then you've got to go to the state that you're in to get an accompanying subpoena to compel their appearance out of state. And it's got to be, you've got to really prove that the witness is important. Like you're going to make them come out of state and then the fees are higher out of state because the travel, you got to pay your witnesses to travel, you got to pay their travel fees. So if he lives out of state now, you know, he very well may have just agreed to come in so that the prosecution didn't have to go through with that, but otherwise they would have used that process. And I see you guys all saying she was also an abuser, which I don't think I was necessarily aware of that. So, you know.
Members of our jury, thank you so much for your time, your attention, and your participation in this very important process. It is 12:21. At this point in time, we're going to go ahead and take our lunch break. I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time outside of here, 12 Alpha in the Orange County Courthouse. And I'm going to give you an instruction. You're going to hear this instruction a lot over the next couple of days. Jurors, you must not conduct any.
So what did he say? 12:15 they'll be back. So here's the question. What's everyone think about the sound and the stream? Should we stay with where we're at? Because we're going to break for lunch because I've got work to do. And then we'll come back. 2:15. Wait, what time do you say? Where are they? They're in Florida. They're in the same time as me, right? Because I'm on Eastern time right now and they're on Eastern time. Okay. Everyone says the sound has been good. And I trust that all you guys, that are at 2 p.m. Wow. Gosh, that's exciting. It gives me a lot of time to work. So I will do that. And then we'll come back here at 2 p.m. Eastern time, 1 Central. And everyone's saying the sound is good. And right, I am not in Central time right now because I am in Indiana. And I guess they'll probably take a break in about an hour. I think, did Bob say that he was going to try to live stream on the break? I think he might have mentioned something like that. But I don't think they just make sure they didn't say anything.
Investigation on your cell phone device places involved in this case. You must not watch local about the case or ask this case face to face. Do not send or accept any messages related to this case or talk. With that, members of the jury, please your service. Y'all may be seated. Thank you. Address. Defense. All right, Ms. Boone, I just got a couple of inquiries of you, ma'am, before release. Are you satisfied with your attorneys so far throughout this trial? Yeah. And are you on board with the strategy that they've employed so far in this trial?
Wow.
Thank you very much. We'll be in recess till 2 o'clock. Court's off the record.
There we go. So that's unusual. I mean, I could see he's just really, I don't know. You guys, I don't remember that happening. I think Banfield was Florida, and I don't remember them being like, do you agree with your attorney's trial strategy thus far? I swear, this judge does not agree. And in my mind, what he's doing is establishing this is strategy. She's agreeing to it. He's kind of making sure that there's no ineffective assistance of counsel claim later for the way everything has gone so far. Brooklyn says that they asked Ashley at the end of trial. That it is normal to ask, have you been, were you satisfied with your representation of your counsel? I've never heard a judge ask, and do you agree with the strategy that's been used? So I don't know if you guys have heard that as well, but I think what he's doing, because look, he's told this defense team, do what you will, but if you can't establish an overt act, and if you can't lay the factual predicate for self-defense, that's on you. And what we heard one lawyer say is their overt offense was those 2 fingers coming out, which the judge was clearly, he wasn't going to be like, that's absurd, rethink your strategy. But if you had picked up on any social clues whatsoever, or even courtroom clues, or, your typical judge's response, you would see that was basically not flying. At least that's what I thought, So I think the judge has taken that little extra step. And like I said, maybe I'm wrong. Maybe he asks other defendants, and are you happy with the strategy that they're moving forward with? I think he's just trying to make it a little harder for her to later claim ineffective assistance of counsel, because he, like you guys said, he's aware of her history and every lawyer that she wasn't happy with because they weren't doing what she wanted, and blah 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 blah, so on so forth. And I agree with Steve. This judge is awesome. Why isn't it letting me? So, all right, we will see you guys back at 2 Eastern, 1 Central. See you guys soon. How do I do this outro thingy?